I want to start by welcoming everyone who's here today. We appreciate you guys coming downtown, braving the traffic and construction to get here, so thank you. Also want to give a special welcome to our clients who are here. We see a number of you, and we are proud to be your lawyers, and we love to see you actually in person from time to time. I'm just going to give a couple comments about the format of the program today, and then I'm going to hand it over to our exceptional panelists. First comment is that we've got question forms in front of you, and given the size of the group, we're still expecting a lot more to fill up these chairs and even part of our overflow room. So given the size, we probably can't take questions during the program. So if you would please write your question down on this slip of paper. We'll have people walking around collecting them from time to time, and then we will do a question and answer session at the end. If you write a question and you put your name down and you don't get your question answered during the question and answer session, one of the attorneys will call you after the event and make sure that your question gets answered for you. The other thing that is in front of you is a green evaluation form. And not really everyone's favorite thing to do at the end of the day when you want to get out of downtown and get home, but we really do ask that you take the time to fill this out because it really helps us in crafting future programs to make sure we're delivering topics and presentations to you that you actually find useful for your business. All right, getting to the substance now of today's program, our topic is investigations, and we've called the program Beyond Me Too, Conducting Effective and Privileged Workplace Investigations. The setup for today's program is that we have two panels, followed by a question and answer period, and then we have a reception out in the hall. We're not going to take a break in between the two panels or in between the question and answer because we have an incredible amount of material to cover. So you should feel free to get up at any point, even in the middle of somebody speaking. No one's going to be offended, and head out to use the restroom or take a break for any other reason. All right, with that, you guys might have better clicker for this. There we go. Our first panel today is on conducting effective workplace investigations, and I'm going to let our panelists introduce themselves, but just briefly, we have Karen Shanfield here, who is one of our own at Fredrikson. I think several or many of you in this room know her, or at least recognize her name. And we also are just delighted to have Ruben Mayanes, is that right?
Yeah.
From Medtronic, who's a senior legal director there. So it's not every day we get to have on our panel someone from the business community who sees investigations from a little bit different perspective. So we're thrilled to have you here. And with that, I'll turn it over to the two of you.
Thank you, Pam. I will just say a quick word of introduction and then turn it over to Ruben. But welcome again to all of you. I see a lot of familiar faces, which is always heartwarming in a group like this, and some new faces that I'm hoping I can connect with you later in the day and we can talk just casually or about things that are on your mind. As I said, my name is Karen Shanfield. I have done a number of investigations. I have overseen investigations. I have represented individuals who are witnesses in investigations and have even had the great pleasure of having my deposition taken related to an investigation that I conducted. And I survived all those things. So I'm glad to be here with you, and particularly glad to be with Dulcie, Lucine, and Ruben sort of sharing our insights and experiences with you. And we hope that you'll find this really useful and helpful. So I'll turn it over to Ruben.
Great. Thanks, Karen. So Ruben Mianis, I am an attorney at Medtronic in-house. I've been there about 12 years. I was in a law firm for about 10 years before that, old Lindquist and Benham, if anyone remembers that. It's changed recently. In the law firm, I did investigations in-house. I oversee investigations and I train on investigations. So we've made a decision that we are going to have our attorneys not do the investigations, but actually oversee it. Part of that is for an attorney-client privilege that we want to keep in certain situations, or at least be able to make that argument. And like I mentioned, I've been there for 12 years. We've done recently, in the last year and a half, kind of revamped our investigation process training. So hopefully I can share a little bit of that insight with you and talk to you a little bit about how we look at it. There's probably some differences being a very large company as to be a smaller company, but I think a lot of the foundations and fundamentals for it kind of run across the gamut of whatever size you are. So I'm going to go ahead and get started because I know we have a limited amount of time. So one of the first things we talk about is, why do we investigate? And I think there's a number of reasons you can point to. I mean, you can say, hey, legally we have to investigate. There's laws that require us to do investigations to avoid liability, especially when there's sexual harassment claims. The courts would expect us to do an investigation and take prompt and remedial action. I think beyond that, and really important for companies, is really it helps to drive culture. What I always talk to the groups that I support about, and the managers and the HR and ER, is I would much rather hear from an employee and have an employee bring an issue forward than hear from an attorney representing that employee. Okay? And at Medtronic, we have this whole a culture of we're a very heavily regulated medical device company. So we have this see something, say something with respect to our quality issues, because again, if there's quality issues that are going to impact patients, we want to know about it. We don't want to hear about it from the FDA. We want to know about it so we can address it. It's the same driving force in terms of kind of the workplace harassment, workplace issues. We want to know about it internally so we can address it. We don't want to find out about someplace else. And if you are hearing about it internally, what kind of a culture do you have? You're having a culture where employees feel comfortable bringing issues forward. If they're not bringing them forward to you, then they don't feel comfortable doing that. They're afraid. They're afraid of retaliation. They're concerned about how it might impact their job. And that's not what you want to drive towards. And I think that goes to the next couple points up there about ensuring fairness. We do investigations to make sure that if people feel they're being treated unfairly, there's a process that we can address those issues through and make sure that they're handled fairly and that their issues or concerns are being heard. And the promoting diversity piece, again, is a big piece that I think is really important. For probably many of the companies that you work with, especially innovative companies, you want to have a diversity of opinion and viewpoints because that helps drive innovation. And if someone looks at your company and says, hey, they have all these issues, women must not be treated very well there. People over 40 must not be treated very well there. Why would I want to go work for a company like that? You're going to lose out on really good people. So there's a lot of reasons to investigate beyond just legally you have to do it. Okay? And I think that's an important thing to remember. I think that's one thing that we try to push as well, because if you do it the right way, if you have a process in place, if you're mindful about how you do it, I think you can really drive a really great culture. And I think in a lot of ways, and I talked to Karen and Pam about this, I think in some ways, some of the corporate companies, and we've been dealing with some of the sexual harassment issues and the training and the investigations for longer than some of the stuff that you see in the news, for example, like in Hollywood. And I think in some ways we're beyond that. We haven't necessarily seen a huge uptick, which you've seen in other areas. And I think part of that is because we've been thinking about this and have a process in place. But you have to stay on top of it because things always will change. So when do you investigate? So I think, we talked about the why. As soon as you become aware of any violation of your policy, I mean, most of you probably have policies in place. There's legal obligations that you have. If someone brings an issue forward, if you become aware of some possible misconduct, any kind of internal complaint process that you might have, those are all things that could trigger an investigation. You might get an EEOC complaint. I mean, hopefully you've heard about this issue and you know about it before you've received a complaint, because again, that means people are coming to you first. But if you haven't, it's the first time, and all of a sudden you get an EEOC complaint or a local, a state Department of Human Rights complaint, you need to investigate those issues. You need to find out what's behind this. You want to take some prompt action to find out what's going on. You might get a letter from an attorney saying, hey, I'm representing your employee. This is what's been happening to your employee. Before you can respond to it, before you can really go through it, you want to start an investigation. You want to gather information, facts, so you can address that situation. So those are all reasons why you want to investigate, or when you want to investigate, when those things would come up. And there's a lot of things, a lot of ways that complaints can come in. And I think you have to be mindful of that. I mean, you may have a formal process. Medtronic has a voice your concern hotline. So employees can either call in anonymously, they can use their name. And even people outside of Medtronic can call in. I mean, it's on our website, and we've had people call in outside. We have a process where every call that comes through will get looked at and investigated. So you may have something like that in your company. But there should be a lot of different options and ways where complaints can come in. You want your employees to feel comfortable that, okay, I can go to my manager, I can go to HR. If I don't like my manager, I'm scared of my manager, I don't think HR is doing the job, who else can I go to? What are the other ways and avenues that a complaint can come in? So I think as you're setting up your system and how you want to investigate in your foundation, those are some important things to think about. It could be through an exit interview. Okay, if someone comes and says, I'm leaving because I felt sexually harassed by my boss, you're not done just because, oh, well, they left, so I guess we don't have to worry about this anymore, right? So you do, because that person, the boss is probably still there, could cause further liability. So that's a complaint that could come in. We talk to our managers about things that they may see. It may not be their direct reports. It may be somebody else. It may see another person engage in inappropriate behavior or what they might think is inappropriate behavior. They have an obligation to bring that forward. Hopefully, all of you, I think most of you are in an HR role. Hopefully you understand that if managers hear about something, see something, they have an obligation to bring it forward, because what they know, the company is going to know. And I always try to drive that home with our managers so they understand the obligation. If an employee comes and says, hey, I want to tell you something in confidence, I'm being harassed, don't tell anybody, I'm just coming to let you know, please don't tell anybody. Okay? They have an obligation to bring that forward. That's something that we need to look at and investigate. Okay? Social media is a big one now. Again, there may be, we have, and this happens as well, we'll have employees, and it's probably not surprising, but we have a group that will scan social media for mentions of Medtronic. And if there's issues that come up, and every once in a while, there's maybe an employee who will mention something that happened at work, mention at Medtronic, or we'll have people that'll complain about our employees and say, hey, your employee posted this. They're identifying themselves as a Medtronic employee, and here's these awful things they're saying. And you should do something about it. Why do you want to employ somebody like that? Okay. So those are all different things in this broad world that we have now, especially with social media, where you may have to investigate and look into some of those issues. So it can come in through a lot of different ways, a myriad of ways. So what is a successful investigation? What does that look like? I think you want to make sure that there's a clear scope. You want to have an idea, what am I investigating? What is the issue? And be very clear about that. We'll talk about who may do the investigation and reasons why you might pull in one person rather than another. But it's really important to understand what the issue is. So as you start the process, what is the complaint? What are the issues? What am I going to focus on in this investigation? The other piece is that the key is really who the investigator is. Not everyone can do investigations, and not everyone can do every type of investigations. You want somebody that is impartial, and I'll talk a little bit more in a few slides about how you pick that investigator and what are some good characteristics of that investigator. But you want someone who's going to be seen as impartial and credible. It's very important. How quickly we can do the investigation. The law and the courts talk about being a prompt and thorough investigation. So you want to make sure that we're going to be able to jump on the issue, investigate it thoroughly, but promptly in a timely fashion so that we can address it. If someone brings forward a complaint about, we're talking about sexual harassment and about some really bad behavior, if it's 4 or 5 months down the road and nothing has been done, that's going to create some distrust in the process, and it's going to create even more problems. So, we want to make sure that we can address things quickly. An investigation, a successful one it'll usually entail a number of people being interviewed. Okay? That's another thing that you'll see is sometimes bad investigations, they maybe go to one person, interview one person, and think they have all the information. Or they'll interview the complainant, and the complainant might say, there's at least 5 other people who witnessed what happened to me. Okay? And we don't interview any of those people. We just go maybe to the person who is alleged to have done the behavior. And, well, it's a he said, she said, or a she said, or he said, he said. We just, one person's saying this, one person's saying that. But we never went to the people who may be witnesses. You see that happen sometimes because people want to do it quickly. And that could be a problem. So think about who you're interviewing, what documents. Usually there's going to be a review of documents. There's typically always documents. And careful documentation. So as an investigator, you want to have kind of a process. Think about, let me just ask you now, how many of you will do reports or require report writing for all of your investigations? Okay. So, a good number of you. Not everyone does. And, it's a question of, I'm going to just share a secret. Medtronic doesn't all the time either. We're trying to get there, but when you're trying to get through, it takes time to write reports, right? It takes time not only to do the interviews and take the notes, but then it takes time to put them into a nice package and put it into a report. But it's important to have that documentation because it really can show if you do have a dispute down the road, what information did we look at, what information did we gather, and it really can provide a good defense for you and show that you did what you're supposed to do as an employer. So the documentation is an important piece as well. Okay.
Ruben, I
Yeah,
know we
go ahead.
asked people not to ask questions, but I am going to. Anyhow.
Yeah.
So have you guys ever been challenged on any of your practices? Has there ever been a claim that somehow the investigation wasn't handled appropriately?
So we haven't officially.
Okay.
I will say that we've had some mediations where the mediator has asked to kind of look at our investigation and kind of provided feedback. I will tell you, because I think Karen and I were talking about, so this is maybe why you asked the question, but there is a group, and I think we reference it at the end of the materials, called Association of Workplace Investigators. It's when we were looking to revamp our internal investigation process and training, we looked for someone to see, are we missing anything? Is there any best practice out there? And it was really the one group that we found at the time that did like a week-long training. And they're mostly based in California. And they're external investigators, so a lot of them aren't in-house. But what I learned from talking to a lot of them is that, especially in California, it's not uncommon that the investigation gets challenged. It's so not uncommon that a number of these individuals actually make a pretty good living being expert witnesses in those cases, because they'll get brought in to look at the investigation and give an opinion on, was this a well-done investigation or not? I don't know that it's really moved, into the Midwest. I've heard like 1 or 2 on the East Coast, but a lot on the West Coast. But that doesn't mean it's not going to come. And that's another reason why you want to make sure that, get to a point where you have very good documentation. So thanks.
You can do that when I'm talking to.
Sure. All right. Some other things to think about for a successful investigation is that, we do really want to make sure individuals are protected during and afterwards from retaliation. It's important to have a no retaliation policy, and that's, something that you would communicate to everybody that you interview, is that, our company prohibits retaliation for being involved in the investigation, for taking part in it. And that means, that you can't be disciplined, you can't have an adverse employment action, you can't have somebody, retaliate against you in any way for being part of that investigation. And that, and I don't know if Karen has seen the same thing, but I will say that I think the retaliation claims are probably more prevalent than actually sexual harassment in terms of, for example, we may get a sexual harassment claim and we would investigate it and we would find that really it's not sexual harassment. There wasn't any inappropriate behavior. But then the manager is so mad at being accused of that they have a hard time treating that employee fairly in the future. And then we get a retaliation claim. So then out of nothing, basically, now we have a claim, now we have an issue. So, but again, think again, what happens if there is retaliation? If I bring a complaint forward, and even if it's found that the complaint isn't justified or there's no basis for it, and then I get retaliated against, or I'm a witness and I give information and then I get retaliated against, how likely is it that I'm going to participate in anything like that again, right? How likely is it that any of your employees hearing that will want to bring any issue forward? And then going back to our first slide, where's your culture, right? You lose all of that if there's any retaliation. That's why it's so important to be on top of that and be mindful of it and watch for that. So again, a successful investigation isn't just during, but it's also kind of what happens afterwards and what safeguards you put in place. We want to protect confidential information. We consider the investigation to be confidential in nature. You have to be careful to some extent. I mean, someone may say, I want to give this to you in confidence. And there may be some things that we do have to share. And I think you have to be upfront with the witness or the complainant about that, okay, I'm going to keep this as confidential as possible, but to do a thorough investigation, I may have to ask questions. I may have to share information to get responses or feedback from that. But in general, I think you want to make sure that we're protecting the information, and especially the information gathered. You don't want to have notes, whatever, that are just laying around that anybody can see. So you have to be careful about that. Think about who's doing the investigation and where the information they kept. Do they have a safe place to keep it? Are they putting notes on a computer system? Are they able to wall that off so that not anyone can just go in and look at those files? I mean, those are some of the things you want to consider. Who's had an investigation where you thought you were investigating one issue and then all of a sudden there's a whole nother issue that comes up? No one? Yeah. I mean, pretty much everybody, right? I mean, so that does happen. You are going to have cases where you start thinking, hey, I'm just going to be dealing with this one issue. And then all of a sudden you start interviewing somebody and now there's all these other issues. That doesn't mean, hey, I'm not investigating that. I'm just supposed to be doing this one thing. All right, we're going to forget about all those other issues. You can't do that. But when we talk about scope creep and how it's appropriately addressed, maybe if you're doing the investigation, you go back to the person you're working with and say, hey, these issues came up. How do you want me to deal with it? That's how I would expect someone doing an investigation for me to come back and talk to me about it. So we could address, all right, let's add this piece to it. This is going to maybe take a little bit more time. Or are you the right person to do this? Now they're talking about quality issues, not just a harassment issue. We need to maybe get somebody from the quality department here that understands what they're going to be bringing up. So we may have to shift it a little bit, but we need to address it. But how are we going to address it within the investigation we started? And I think I've already touched on how we want to make sure that all key individuals are interviewed. That's not to say if someone says, hey, everybody in my department knows, you should talk to everybody. And there's 50 people in that department. You're not going to talk to all 50 people, most likely, right? I mean, but you're going to talk to a couple of them, a few of them. You may drill down a little bit and say, okay, I understand that everybody may have that perception. Is there anybody who overheard it or who witnessed it? Maybe start with those individuals. Maybe pick a couple. And if you have a couple that confirm, do you really need 50 people that confirm? I mean, there's that balance that you're going to have to go through, okay? Because again, interviewing 50 more people, that could take us a month. That's not going to be a timely investigation. So those are things to think about. And then also, the successful investigation, especially when, the report writing, you want to see that there's some thoughtful analysis here. When I told you about these challenges to investigations that are going on in California courts, they'll look at, well, they have all the information that supports that, but there in your notes, you have a lot of things that didn't support that. How come you don't address that in your report? All right? A good report would show, here's the information that supports the allegation, here's the information that doesn't, and it would weigh it and balance it so that it shows, hey, I considered this. I was aware of this information. I considered it in making a conclusion here. So that's another thing just to keep in mind as you go through that. And then I think it's also important, once the investigation is complete, think about how we're going to communicate those results. What is the follow-up going to be? We're constantly learning kind of new lessons. We know that bringing forward complaints about harassment, for example, can be very emotional. But I think sometimes we forget that we need to have that follow-up. And I think you need to read that individual, just to not, I mean, and sometimes you're not going to be able to tell them every little piece of information that you gathered or what the result is. But I think some follow-up saying, I'm almost wrapping up this investigation, because they're wondering what's going to happen. And some follow-up to say, hey, I either corroborated what you told me, or I didn't. The conclusion is that there was some bad behavior. We're taking appropriate action. The conclusion is that no policy was violated, but we saw some opportunity to do some coaching and better the communication between you and your manager, or you and your coworker. So some feedback to let them know, and some follow-up. And then I think also it's important, and this isn't necessarily my viewpoint on this, is that it wouldn't be the investigator who would do the follow-up necessarily. I think you have somebody else do it. I mean, to me, the investigator is a neutral fact finder, and their job is really just to gather the facts. Now, again, smaller shops, smaller businesses, you may not have the luxury of having a lot of people to do that, but think about that. And then also the discipline piece of it. Once the finding from the investigation is there, what's the decision about the investigation? What are we going to do? Is there going to be discipline? Is there going to be termination? Are we going to, is the behavior bad enough? In my investigation, I pulled their computer, looked through it, there's porn on there. Is it child porn? Well, if it is, then we're going to have to report that to law enforcement. I mean, that's just an example. I mean, those things happen, and you need to be aware of that. So those are all just things that, a good investigation at the end, you're taking the appropriate actions as well. I mean, if you have a finding of some really bad behavior and there's no discipline or no steps taken, then you're going to have a trouble if there's ever any, lawsuit or challenge to that investigation. Okay. All right, so choosing the investigator. I think this is really key. Again, I mean, I think a lot of these are self-evident, but it's important to think through this. Investigators should be impartial, and they have the necessary demeanor. Not everybody is comfortable asking about sexual harassment issues, right? Not everybody is comfortable having to look at some of the sexting that you might have going on, or the text messages, or the computer pictures. So I think you have to think about who you're having do the investigation. Not everybody has the appropriate demeanor. We did some training early on with some of our security officers as well. And some of them are great, and some of them do have a mentality of, I'm going to sit you in the room and I'm going to flash the light on you, and you're going to tell me everything you know, okay? And in some situations, depending on what it is, that's not going to work. And some of our HR, ER people, are almost even too nice. So I mean, it can go either way. So I think you have to figure out what the best demeanor is for that. And it's not a problem not to be able to do that investigation, or even not being comfortable with it. You should be aware of that. We could spend a whole training on just implicit bias, or bias in terms of that we might bring to an investigation. But that's another thing to be honest with yourself about and think about. Are you really going to be able to handle this investigation in a neutral, fair way? Does the person have the time to conduct the investigation? Okay, because we need them to jump on it now. Are they going to have the time to put into this and really drill down? Because we want to do this the right way. So that's important. Good listening skills. I think in general, an unintimidating demeanor is a very important attribute. You want to have somebody who's willing to listen and can sit and take information in. And not only listen to the information, but then be able to hear the information, because then they can ask questions that are appropriate as follow-up, okay? And not just stick to a script. And then that maturity, I think, is also a key. Some of the investigations that we're talking about, you don't want them going and talk. I mean, I think Karen and I probably would tell you that we like being in employment law because of the different stories we hear. I mean,
It's juicy work.
yeah, it's juicy work. For as long as I've done it, almost every week there's something I'll say, you got to be kidding me.
Right.
I don't think I've ever heard that one before. And how could that happen every week? But it does. So, but I think, you want to have investigators that aren't going to be sharing those tidbits and talking to other people about it, or spreading that information around. You have to have people that are going to be discreet and mature enough to handle that as they go through it. Okay. And when you're planning out the investigation, who's going to do the investigation, I think it's also important to talk about, position of the accused. Are we talking about a high-level executive within the company? Okay. What is the conduct? Is it very severe conduct that we're talking about? Is it really sensitive type of issues? What's the potential liability? All that may play into who we're going to have do the investigation. Do I want to have a lower level ER person do employee relations or HR? We use different terms in Medtronic. It changes almost every year. So right now it's ER we use. But do we want to have a lower level person investigate a vice president? Is that going to create some issues for them in the workplace later on, right? Is there going to be a potential for retaliation? Would it be better to have somebody from the outside come in, given the sensitivity of the issues? Would that seem more fair? So those are all, I think, issues that you want to bring up or think about as you're choosing the investigator and choosing how you're going to investigate. What's the relationship with the company, the individuals involved? Obviously, if we ask people to recuse themselves if they have a relationship or they know the individuals that they'd have to interview very well, or if they've worked with them a lot. So again, we have the luxury of having a big company where we can pull in different people from across the businesses. But those are things that you should think about, and there's lots of different options. So human resource personnel could do it, in-house counsel could do it. Some companies do have their attorneys do the investigations. We've chosen not to for the reason I've told you. Outside counsel, okay? You can bring in Karen, you can bring in Pam to do the investigation. Outside consultants, there's firms in the Twin Cities that do, investigations and have investigators that are external investigators that will do those types of investigations for you and are very good at doing them. We've kind of used the gamut. We've used all different. We've had, the only thing I'd say is that we really don't have the in-house do it, again, because we want to have the in-house directing the investigations, and probably because we don't want to be deposed like Karen was deposed. So we don't want to we want the HR to have to deal with that stuff. So that's how we've set up. But there's a lot of different options that you can pull in, and again, I think it's important to think through that and think who would be the best for that particular investigation. Oh, did I miss one?
I just got a little message from the back about timeliness.
Okay, how are we doing?
We got to hustle.
Got to hustle? Okay. All right. So, I think some of this I think we'll be able to get through a lot of this pretty quickly, actually, because we touched on a lot of this here. So the scope, what's the complaint? Think about what we need to consider. Pull in the policies, the rules that might apply. What documents? Electronic communications is important. Laptops, smartphones can be a wealth of information. People think they delete stuff and it won't be there. No, it's there. All right. If you take your smartphone and you think, hey, I'm just going to text because no one will ever see the text because that's not saved. Well, if you hook your smartphone up to your laptop to charge it, a lot of times it'll automatically download everything and make a copy of it. Okay. We found lots of good stuff that way. So it's just something to think about. And, those are different devices and things that you can get more information. So think about that. So the electronic communications, if your company has kind of a process where emails are deleted or anything's deleted on a regular basis, if that's coming up quickly, you may want to make sure that those don't get deleted because you want to make sure that you gather that information, you have that information available. Sometimes there are video cameras in facilities. We do have some facilities where there are some video cameras, and so we'll pull that information at times that we need to, and it can be very helpful. It shows somebody walking to a desk and putting a note on the desk when they said they didn't. So that has been helpful as well. And there's a lot of just other opportunities that you can pull that. So be creative a little bit. Think about where the information is and what you might be able to pull. As the investigator is doing the prep, are there some certain things you want to pull? I think personnel files are sometimes good. I think there's this balance between getting too much information on the front end. And you want some to have some background so you can ask good questions. But at the same time, if you get too much information, sometimes that sways the investigator a little bit and it kind of closes them off to asking certain questions and being more open to getting more information. So there's that balance. But I think in general, having a personnel file and having some background information is good. Think about where you're going to do the witness interviews. That's a really important piece. You want it in a neutral, private place. You don't want it in the glass open conference room right in the middle of the floor of the building, right? Where everyone's going to see who's going in and going out. You don't want it right next door to where the person's manager sits. So think about where you do it. If you're able to do it on the other side of the building, do it on the other side of the building. If you're able to do it maybe earlier or later, I mean, just think about how you're doing that and where you're going to do it. And, I think in terms, in general, I think you're going to talk to the complainant first, talk to some witnesses first, talk to the accused. But again, that may change, and there's no, I think there are some basic ways you want to follow it, but you can have some flexibility in that as well. All right. Just real quick, I think it's good for the investigator to be prepared in terms of, what do I want to go through? Have an outline of questions. In general, we use a toolkit. I think it's a good idea. So we have some consistency in terms of how we approach it. We have a consistent opening statement that we usually read that includes talk about retaliation. We have a closing statement that we use. So we try to drive some consistency in our investigations. So it's not a bad idea. We have some consistency in terms of when we reach out to talk to witnesses to make that contact, what language do we use? How do we do it? I think those are all really good. The Weingarten rights and the Upjohn rights. Weingarten, does anyone have union employees or unions? Okay, so you're probably aware of that. It's basically just if there's an investigation, if there's an employee who's part of a union, they have a right to have their union rep there during the investigation. So it's just being aware of some of those rules. The Upjohn right really plays in when you have an attorney, like an in-house attorney or maybe even an outside attorney that's representing the company do the investigation. They have to let the witness know that they're an attorney representing the company. They're not the witness's attorney, and that this conversation is going to be an attorney-client privilege conversation, but it's a privilege that the company holds, not the employee. And it's important to provide that so the person who's being interviewed understands that. So they don't think that they're saying something to this attorney that then they have the right to determine whether or not it can be shared or not. Okay. So again, we could go into more detail on that. If you have questions, we can touch on that. And actually they're going to be following up on that. So good.
We're going to hear plenty about that.
Yes. Is this my last slide? There's just about, okay.
Yeah.
So I think, again, we've talked about most of this, the scope of the investigation, purpose. I think I'm going to skip that because I think we've gone more through that. I think the focus on the facts is the key thing. You're a fact finder. The investigator should really focus on gathering all the facts available and ask the right questions. I'll just touch really briefly on this in terms of the challenges. Be prepared. Be prepared ahead of time. Again, what we've tried to do with our toolkit is think about some of the questions that you'll get. Can I tape this conversation? Are you taping this conversation? Can I have my attorney present for this interview? Those are all different issues that can come up. And I think knowing ahead of time how we're going to address that from a company perspective and what your stance is going to be on that is really important because it can derail the investigation from the start if you're not able to answer or respond or move forward on it. And manage emotions. I think it's really important to understand ahead of time, is this going to be a very emotional one? Be prepared for anger. I think if you're prepared for that and think through what might happen, what happens if they start yelling at me? What happens if they start crying and breaking down? What do I do? Do I have tissue available? Do I have water available? Am I ready just to say, hey, let's just take a break? Let's just take 5 minutes and come back. If you have that thought out ahead of time as an investigator, you're going to be in a much better spot. So those are all important pieces to think about before you even ask the first question. Okay. All right, so I'm going to turn it over to Karen.
Thank you, Ruben.
All right, sorry if I went over.
No, it's fine.
Okay.
So how many of you have done an investigation yourself? Okay, or think you will be doing one? Same. Are you seeing a lot more recently? I'm sort of in this mode where I feel like everything's getting investigated suddenly, that things that didn't maybe rise to that level in the past are starting to rise to that level. So I think it's important to sort of think about our skills as investigators. What do we bring to the table? What's important? What's not as important? And just dust those off to make sure we're doing the best job we can. So when I do an investigation or oversee an investigation, one of the most important things to me is to make sure that I stay focused on getting all the facts. That's my job, is to get the facts, and whether I'm acting as a lawyer and presenting legal advice, or I'm acting as a fact finder and just presenting facts, that's my job, is to find out the facts as best I can. But the other part of my job is to make sure the process is a good process, and I do that for two reasons. One is so that in this process, these individuals will believe they've been treated fairly. That's very important, because I don't like having my deposition taken. And I'd like them to walk away and say, yes, that was a fair process, even if I'm not in agreement with how it came out. The other reason is because as there are more investigations, I think it's very, very important that you sort of normalize that process, and there is a sense of we trust that process. The easiest thing for somebody who's accused to do is to come back and say the investigation was unfair. And the chances are very, very good that the person who has been accused and the accuser, either or both of them, will continue to be your employees. And at the end of the day, when they go back into that workforce, or other witnesses are back in that workforce, you want them to say, you know what, we've got a process for handling problems. And it's a process that I respect, and it's a process that has integrity to it. So if you're investigating something, I think that should be top of mind, along with getting to the issue, getting to the bottom of it, and understanding what the facts are. So to my way of thinking, that's very important. I do generally like to see as much in advance as I can. I know some investigators feel differently, and some people think, well, I don't want that to taint my view. But I feel like coming in well prepared, the more I know, the better. And having the ability to put that to the side and not rely on it, not let it be impacting my findings is important. And sometimes I'll even say in a report what I saw and when I saw it. So here's a list of the documents, here's a list of the people that I talked to, here are the conclusions, here's what the issue was. So I think that's important to lay out. One of the other things that Ruben talked about was the importance of a prompt investigation. There's no question that's important. It's important for a couple of reasons. One, of course, the law, when it's sexual harassment, says we have to have a prompt investigation. So even if your investigation process itself isn't challenged, but it has taken you a long time to get launched, then you're not going to have a prompt investigation, and then you could possibly be challenged on the sexual harassment piece of unfair grounds. So you want to be cautious about getting it launched. And one of the things that means is if you're overseeing the investigation or you're conducting the investigation, you're going to have to be a little bit of a nag, because guess what? Not everybody wants to talk to you about this issue, right? It's getting those witnesses in, getting the complainant in. The complainant's often reluctant, even though they've brought the matter forward. Certainly the person being complained about isn't thinking this is going to be their favorite thing to do today. So the person really has to drive that. Again, whether it's the investigator or the person overseeing it, getting people organized, getting them in, choosing a room, making sure that they're all told consistent messages, as Ruben mentioned. All of that really matters. I call that the administrivia of investigations, right? We have to get that part right at the very beginning. It really makes a difference to the outcome and to the quality of the work that can be done. And then during that interview, I think, again, besides getting the facts, you are creating trust with that individual, whether they're the complainant, whether they're the person who's accused, whether they're a witness. You want them at the end of the day to trust you and to believe that the process has been fair. I think I've got my slides here slightly out of order, so I'm going to just back up here. When you're in the interview, here, let's go to this one, which starts with creating rhythm and rapport. Again, at the beginning, I usually introduce myself to the individual. I'd expect anybody who's doing an investigation would say a little bit about their background. enough to establish rapport, enough to show that they have some sense of what they're doing, that they're reliable, that they're credible, that they're going to be fair and objective. And I look for opportunities in the course of the investigation to use those words: fair, objective. Sometimes I say driven by the facts. I'm going to follow the facts wherever they lead me. I think repeating those words as part of the process and making that the mantra helps establish, again, the credibility of the process and the fairness of the process. And of course, we want to make sure you get it right as well. I usually move from general questions to specific questions. So we start out very generally, not leading the witness at all, but having them tell their story. And it'll be question and answer, but that doesn't look the same in every interview. Some people, it's question, answer, question, answer, question, answer. Some people, it's question, answer, 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 go around corners, go under trees, whatever it happens to be, and then finally we get back to the next question. And I typically let the witness sort of direct that. I don't try to force people into answering according to my questions. I don't ever come into an interview without a list of questions and sub-questions and follow-up questions. I usually do that preparation in advance and like to come in with that with me, but I don't feel compelled to follow that script. And I think it's really important to let somebody tell you their story in their own way, because how they tell you their story will tell you something about them and about the behavior, and it will also, I believe, elicit better information and more reliable information. If you try to pigeonhole somebody who is not a lateral thinker into responding in a lateral fashion, you're not going to get good, meaningful answers. And again, that's your goal, right? Is to get to the heart of the matter, to understand what happened, to get the facts. You might have to follow up to get a clear story, especially the person who wanders. You're going to have to bring them back and say, this is what I understand. Do I have that right? Have I missed anything? And this is not to say I wouldn't cut somebody off at some point. I would, but I try to give them a good amount of latitude. If they want to consult their calendar, their emails, talk to their lawyer, if they have a lawyer and the lawyer doesn't happen to be in the room, I generally allow that because, again, two goals. One is to get confidence in the process, to trust the process, and the other is to get the facts. And I think allowing people to get information is important. I don't like to do interviews not in public spaces, as Ruben mentioned, but I don't like to do them in rooms that feel like they're interrogation rooms. I like the room to be comfortable. I like it to be well lit. I like it to have restrooms nearby so that people can take a break. I have learned to have Kleenex in the room, and so I usually have Kleenex in the room in case somebody needs it. And a lot of what you're doing as you're asking questions or your investigators asking questions is being an empathetic listener. And that's sometimes a fine line to draw, right? Because listening with empathy is not saying, yes, I agree with you. Right? Those are different things. And being a good listener to ferret out distinctions or things to follow up on is incredibly important for any investigator. And to create a sense of, I'm listening to you, I'm hearing what you're saying, sometimes by parroting back, I think this is what I heard you say, is a useful thing to do as well. I think that's a really good technique. And that's different than saying, yeah, boy, that's a horrible thing that happened to you. I just feel awful, right? Obviously, that's not anything you would ever say, right? So you need a little bit of emotional distance from that interviewee. I think it's really important to take notes during the course of the interview, and I always explain that I'm doing that because I want to be accurate. I want to make sure they're careful and thorough. If somebody asks to see my notes, the answer is generally no, but I always tell the interviewee if they ask that they can take their own notes if they'd like to do that. That's fine. It will slow the process down a little, but they're welcome to do that. One question that sometimes arises is, do we have a note taker and an interviewer? Do we have two people present, or do we have the interviewer take their own notes? And there's pros and cons to that. I think it depends on the complexity of the matter. It depends on how many witnesses are likely to be interviewed. If you have a huge investigation and you're interviewing maybe 40 or 50 witnesses, I think you're going to want a second note taker in all those interviews. If you're talking to 2 or 3 people, it may be a little bit less necessary. If you're worried about people people changing their stories, you might want 2 people. So again, lots of factors to think about. And think about who those people are. If you're interviewing someone about a sexual harassment complaint and you know that this is a woman, let's say, making the complaint, and you know that it's very emotional, you want to be thoughtful about if it's 1 person or 2, who those 2 people are, and how they will present themselves physically and sort of empathetically and emotionally. And then I typically will go through various documents that I have with the particular person I'm interviewing. And then I like to prepare a witness summary afterwards. So it's not just the handwritten notes that we rely on, but actually a typed up summary that really just lays out the facts. I know there's different schools of thought on this, but sometimes I will say in a separate section, very easily segregated, if I need to segregate it later in the event of litigation, what my subjective impressions were. And if I do that, I would do it in a separate section, and I say why. So this guy was lying is not going to be sufficient, right? I didn't find his story credible because it was internally inconsistent would be better, or his story was not believable because there was no way he could have accomplished the things he said he accomplished in the amount of time he said it took, or something to that effect. So we're not looking at conclusions, we're looking at underlying facts. That's really what I think is quite important there. And remember that that's just a summary, it's not a transcript. I usually put a little disclaimer on the top that says that. I have little things I do. If I put something in quotes, it means this is exactly what the person said. Otherwise, I don't use quotation marks. So I've got my own little devices, and I'm sure many of you do as well. When we're talking about the complainant, we want to hear from them generally first, as Ruben said, and we want to know what happened, where it happened, when it happened, how many times it happened, who else knows about it, who else did you tell about it, did you take any notes, on and on and on it goes. So we want to make sure that we get as many of those details as we can. And again, sometimes a person will ramble and will tell you all sorts of things some of them are relevant, some are not. And the job of the interviewer is to come back and say, did I get that right? Right? And make sure that you fill in gaps. Obviously, you can come back and do a second interview if you need to, but our preference is typically not to do that. And again, we'll show documents, electronic communications, ask about those, ask if there are others that the person has. One of the things that I think is quite important with the complainant and the person who's accused, who I'll call the subject, is really that we set expectations. In other words, I'm here to understand what happened. I'm going to report that back to your company or whatever it might be. I can't promise you anything. I can't promise the outcome here. What I would like to know is, how did this impact you? What do you think a good outcome would be? What do you think is fair? What would you like to see happen? Some questions along those lines. But again, multiple recitations of the fact that I'm asking you doesn't mean I can control that. I would just like to understand that. And sometimes that helps you later with a credibility assessment or ferreting out other discrepancies in the course of it. Again, when we're talking to the subject, it's much the same as talking to the complainant, except that you should expect either denial or defensiveness or some combination of those things. I have had a few subjects who have come in and say, yes, I did it, and I'm really sorry, and I shouldn't have, okay? That does happen. Sort of the seriousness of being in the room with the investigator and the process having been launched in a company where the process is felt to have integrity. Sometimes people will say, yeah, I did it. How do I get out of this? What did I do wrong? I'm really sorry. Will an apology help? So that sometimes happens, but often what happens is the person denies it, or they're defensive, or they're angry, and they're going to take it out on you, the investigator. So that investigator needs to be able to sort of remove themselves emotionally from the situation, let the person say what they're going to say, and then bring them back to the facts and ask fact-specific questions. Whether you provide a copy of the written complaint or not to the subject of the complaint is another issue that's worth considering. I think typically we don't. We do summarize what's in the complaint rather than providing it. Is sort of my typical process. I know sometimes other people have a different one. And then the big job is really analyzing the information. What do we see when we look at what we've learned from the witness interviews, when we look at what we've learned from the documents that we've been provided, what are our conclusions, and how do we lay those out, either in an oral report or in a written report, so that there's not only a clear understanding of what happened, but the basis for concluding that the investigator concluded that's what happened. And then, of course, it's up to the entity to decide what to do about that information, what steps to take. And I've sort of laid out some of those possibilities and how those are communicated both internally and externally in those remaining slides. Timing sometimes matters depending if you have a union or not and depending on the level of employee who's involved, so you'll want to give some thought to that as well. Okay, so final slide here, careful planning, careful execution, careful analysis, careful communication. That's your takeaway from this portion, and I'm going to thank you all for your good attention and turn it over to Dulcie and Lucine.
They do their
Isn't that clever?
yeah.
I'm going to let Dulcie and Lucine take it from here. I just wanted to do a reminder about questions. Now would be the time to get them in so that I can be shuffling through them while the two of them are speaking and have them ready to go when we start the question and answer period.
Okay, so our topic is privilege. We're zeroing in on that particular issue in an investigation because we've had so many investigations that we've handled involving clients who have a lot of questions about this and who, in some cases, have started their own investigations and made decisions about how to handle the documents and the interviews that actually result in a privilege waiver because of that lack of understanding and end up damaging the client's position in litigation or in a government investigation later on. And so this is the topic that we're focusing on. I'm Dulcie Foster. I'm one of the co-chairs of our White Collar and Regulatory Defense Group. We investigate a lot of things, kind of unlike Karen and Pam. Our focus is on the regulatory and criminal matters. We do handle criminal sexual assault investigations and sometimes harassment investigations. But we also handle things involving financial fraud, securities fraud, corruption, all manner of things, embezzlement, that kind of merge over into the criminal arena. And we have a lot of experience dealing with government investigators and cases where the company may be internally investigating something while there's a government subpoena or a government case going on the outside. So that's what we do.
Yeah, and I'm Lucine Hoppy. I'm a shareholder in the same group. I wear two hats, actually. I'm also our firm's general counsel, and so I actually do function a little bit like in-house counsel on occasion and work on investigations, believe it or not, at law firms. Sometimes we have to do that, too. So we're titling this The 10 Steps to Preserving Privilege. There's probably a lot more than 10, but we wanted to break it down into easy bites for folks. Before we get started, I wanted to take a step back for the non-lawyers in the room and just explain what we mean by privilege. Privilege is a doctrine or rules that apply in court cases whenever there's a subpoena or a government investigation, any other legal demand for a company to produce or an individual to produce documents or information. There may or may not be a privilege that applies that allows you to withhold those documents and information. And it's very useful and helpful to know what those rules are so that you can protect extremely sensitive and confidential information from being disclosed, so that you can protect the nature of your investigation from being disclosed if there's a potential for litigation down the road. And so knowing the rules of privilege is a pretty key prerequisite to conducting a thorough, effective, and good investigation. So these are the 10 basic steps that we've outlined. Nothing, of course, is bulletproof in this area. You can do everything in this list and still end up in a court case where a court says, nope, I don't agree, and you're going to have to disclose the information. So always bear in mind
when you're conducting an investigation that whatever you do, whatever you write down, could end up in a court case being disclosed. And the reason that really matters is because not only will it affect the case that's brought, so if there's an employment case that's brought down the line, it could have an impact on that particular case. But sometimes we discover things in investigations like trade secrets, we discover criminal conduct that's not the focus of the investigation, all kinds of things that the company may want to protect and keep from disclosure in that court case. And so being mindful of privilege is important to protecting the company's interests in those situations as well. Sorry.
Takes a minute, I guess.
Yeah.
All right, so first step we're going to talk about today is learning the privilege rules. We're going to spend a sort of a fair chunk of time on this step because we're going to give everyone here just a little bit of primer in what the privilege rules are. I think we thought it was important. I know that, given the, the attendee list here, you're not all, in-house counsel, and that you are in a bunch of different roles. And I think people commonly might have this misperception that really that's in-house counsel's responsibility to deal with privilege and worry about privilege, but it's really everyone who's involved in investigations in the company. And so that's why we wanted to talk to you, this group today, about these issues, because it really is important that everybody who's involved understands. First part of step one, we wanted to talk a little bit about understanding why preserving privilege is important. At a high level, from a legal perspective, it's important because, in our system of our legal system, we're an adversarial system and we're against each other. And you need to be able to tell your lawyer or talk to your lawyer about anything you want, whether you're an individual seeking legal advice or a company seeking legal advice. You need to be able to tell them the whole story and know that that's not going to be shared, that there's going to be some protection for that conversation that you're having, or you're not going to tell them everything, and you're not going to be able to get the best counsel and legal advice. From a practical perspective, understanding why privilege is important, we've laid out on these couple of slides here. So Dulcie's already alluded to some of this, is, you don't know what you're going to find out during an investigation. I think of our healthcare clients, you may think you're investigating a nurse who is stealing, opioids, from patients. But all of a sudden you sit down with her and she tells you, well, I think this doctor is getting kickbacks from our major medical device company that we're dealing with, and that, we get, millions of dollars of revenue and they get millions of dollars of revenue, and all of a sudden this has blown up into a big thing that could, be public, there could be government investigation. And so you want to be thinking about these privileges and how they can limit exposure to the company for those things. They can limit also, by preserving privilege and keeping that information confidential, you can be limiting legal exposure to particular employees. You can be preventing some business disruption by, if there are accusations made and there's no basis to them and you find that out in the investigation, well, by preserving privilege and keeping things confidential, you may have preserved the company and its employees from having to deal with those things. Dulcie talked about trade secrets and financial data. Some of the other things are, reputational risks, again, both to individuals and the company. We do a lot of whistleblower defense cases, and a lot of wild accusations are made against physicians or leaders of companies that have a public reputation to maintain, and sometimes they're just completely baseless, and you find that out after a long investigation, but you don't want that information being shared or being obtained by an opposing side in a litigation matter. And finally, there's cost issues. You can, it helps you by exercising privilege, or it helps you contain the body of evidence, and it may reduce the number of people that another side at some point learns, oh, did you investigate these 30 people, and now, you didn't make your reports privileged, you didn't work to do that, and now we're going to see all of those, and we're going to want to talk to them too, et cetera. So those are considerations.
It's also important to understand when preserving privilege is important. We do not take the position that every investigation or everything that you do needs to be protected by attorney-client privilege. There are certain costs that come with privilege, the main one being that an attorney absolutely has to be involved. You can't protect something as privileged unless an attorney is leading the investigation, rule number one. So if you're going to have an HR-led investigation, that's not going to be a privileged investigation, and it's not a position that every investigation needs to be privileged. Sometimes you might have a situation where employees are coming and complaining that their lunch in the cafe was stolen. Well, that's probably not something that's going to end up in litigation, might be something that you need to inquire into in order to satisfy that employee and keep that employee happy, but probably not something the company is facing a serious risk around and not something that necessarily needs to be investigated under privilege. The point here, though, is that you can and should assess whether privilege should apply up front based on the information that you know, and make decisions about how to handle the investigation based on that. Some of the questions that I think you should ask when making a call, is it a situation where you're going to end up in litigation? If it is a situation where litigation is likely, you should have an attorney involved, because the attorney is going to be able to protect that information under the scope of that attorney's privilege, and then the company can, at the point that the case goes into litigation, make a decision about whether to waive privilege, whether to keep the privilege, but it allows the company to make considered decisions about what gets kept private and what doesn't. Could it end up in the newspaper? Is this something that's going to create serious reputational risk for the company? Certainly, if that's the situation, you might want to consider having an attorney involved. Could someone go to jail? Are there serious compliance issues involved? The type of case that Lucine and I get involved in, typically there is a risk that somebody might go to jail. Because of that, we always think about this issue and work to preserve privilege. It may not be something that you know up front. It may be something that you have trouble assessing. If you don't know whether something should be kept under privilege or not, always ask a lawyer. Talk to your in-house attorney if you're an HR person, and think about what are the issues that you need to address potentially, what are the risks later on that could cause confidential or investigations information that you don't want exposed to the public to come out. The next thing we wanted to address is understanding what is important or what is protected. So there are two types of privilege. There are two basic types. There's attorney-client privilege, and then there's work product. And those are two completely different animals. There are other types of privilege that can apply in certain situations, but those are the big ones. So some courts extend the privilege to non-lawyer investigators working under the direction of an attorney. So be aware of that. If you are an HR person and you're reporting to an in-house attorney, then what you do in the context of an investigation may also be privileged. Minnesota tends to follow that rule. So if an HR investigator goes out, does some interviews, talks to people, that may be protected under privilege. So just be aware that that could apply. The second bullet I have here, information must involve matters within the scope of the employee's company duties. So if you're talking to an employee about something that they did outside, maybe they went on a drinking bender outside the context of employment, and what the employee does doesn't involve risks to the corporate interest, doesn't involve something that the attorney needs to advise the company on, privilege may not apply. So be aware of that rule. Employees must also be aware that the purpose is to facilitate legal advice to the company. That's a really big one. I have worked with clients before who sent HR personnel out, the in-house department sent HR personnel out to do interviews, and they did not communicate in the context of those interviews that they were working under the direction of an attorney. They did not communicate that the purpose of the interview was to obtain information to give legal advice to the company. We had grave concerns in those cases that the context of those interviews and the things which could have exposed the company to liability would not be protected as privileged. So it's really important to communicate that in context of the interviews. And it's very, very important, key rule, that you have to explain to any witness that you're interviewing the need for confidentiality, or any person that you're talking to about collecting documents about the need for confidentiality. Because if it's not kept confidential, if it doesn't remain confidential, then it doesn't remain privileged. Here's what attorney-client privilege does not protect. It doesn't protect underlying facts. So you may discover something in an investigation that's pretty sensitive and risky for the company. the fact that those facts exist, that you can't, just because you've investigated, because a lawyer has been involved, that doesn't suddenly bring it under the scope of privilege and make it privileged. The underlying facts are never protectable under privilege. What's protected is the attorney's communication, or in the case of an investigator or another agent who's working under the direction of an attorney, that person's communications with the witness in the investigation. So those communications may be protected. The things that you choose to investigate may be protected. The things that you or the attorney advises the company in response to what's learned in the investigation may be protected. But the underlying facts, the fact that John Smith harassed Mary Jones, that's not going to be protected. And the fact that you've used an attorney and that you want to rely on the privilege isn't going to help you. It's also not going to protect non-lawyer management communications about the investigation. And we see this happen all the time, where you have the CEO and the CFO talking about this important investigation the company's going, and they're emailing each other back and forth about it. And those emails don't communicate information that was obtained from a lawyer who was involved. Those communications back and forth, the suggestion that, oh my God, if we learn that John Smith, who's our head of sales, harassed Mary Jones and we're going to have to fire him, that's going to create a huge impact on our bottom line. We're concerned about that the sales in that division if we have to fire him. That's not going to be protected, could be disclosed in court. So make sure if you're doing an investigation like this, that managers, the people that you're reporting to, understand that their discussions with each other about the investigation, if an attorney is not involved or if the communication does not give legal advice, that's not going to be a protected communication. And finally, merely copying a lawyer doesn't create privilege. So you can't just sort of talk to each other back and forth and then say, oh, by the way, CC Ruben Mianis, because you want to make sure that that gets protected as privilege. If the communication is about something business related, if it's not something to solicit Ruben's advice or to help Ruben advise the company about what to do, then it's not going to be a privileged communication. Just copying a lawyer doesn't protect it.
We wanted to talk briefly about another doctrine. It's not technically a privilege. It's a work product doctrine. It's a court-created doctrine to try to help protect attorney work product, attorney opinions, and the development of their case in the context of preparing for litigation or actually doing litigation. So first of all, this is a doctrine that's going to apply to work product created by an attorney or at the direction of attorney in the context of when you're anticipating litigation. And now when that line actually occurs isn't always really clear. I think, in the example I gave earlier, when you start to hear credible, potentially credible allegations that there are, kickbacks, to a big medical device company, you can sort of, at some point in that, you're going to start to anticipate this is going to lead to a government investigation, probably some kind of a complaint and litigation. But that's something that is often litigated afterwards when it comes in front of a court. But you should be aware that this protection is out there when you are working and an attorney is developing work product or has directed you to develop something as part of preparing for potential litigation in the future. You should be aware that this exists. This is a weaker than attorney-client privilege. Courts are very respectful generally of the attorney-client privilege. But the work product doctrine is something that can be overcome if the other side in the context of litigation asks for this material and they can show that there's substantial hardship, that they can't find it any other way, that it contains sort of some kind of facts that they need on their side, and it can be overcome, and courts can order it to be produced even though it would qualify as work product. And the more that the material trying to be protected carries some kind of attorney opinions or mental impressions in it, that is something that's going to have a greater likelihood to be protected. What isn't protected under work products, these are going to be materials prepared or exchanged by employees or consultants that you've hired that they're not acting under direction of investigation counsel. I had a case where actually they started outright, outside counsel wrote a letter to the company ordering an investigation on something, and then completely dropped out of it and wasn't involved, and it was completely run internally by employees in the company with no ongoing direction from attorney. And ultimately, we determined in that case that we couldn't claim that there was an investigation related to this later, and we couldn't really honestly claim work product over that material because of that. And so, and then of course, if there's really an absence of anticipated, if you really don't have a reasonable argument that you're anticipating litigation at a certain point, you're just doing some kind of routine internal investigations or something that's minor inside a company that really you can't credibly say you're anticipating litigation over this in the future. Work product doctrine's not likely to apply in those situations. All right, so the next thing is the where. Unfortunately, for companies who operate in different states or internationally, you're facing a whole panoply of different rules regarding privilege and when it applies and how, and especially internationally. So we just wanted to let you know just real quickly that there are certain states, a minority of states, that when courts are looking to decide whether something is privilege, they're going to say, well, privilege only applies if you're talking, the company attorney is really just talking to a small control group within the company. And if the communications went outside this really small control group of people who really had a need to know, well, that's not going to be privileged. So there are a minority of states that have that rule. And most states have adopted what's called a subject matter view of privilege. And so if the communications are for the purpose of seeking legal advice and the communications relate to the subject matter of that legal advice or the investigation that's taking place, that is probably going to be protected. Minnesota oddly there's a case here in Minnesota where they considered both approaches and they kind of denigrated both of them and said, we don't like completely either of those approaches. And Minnesota takes an approach that's a little bit of a hybrid of that. So they're going to look at, was the communication for the purpose of securing advice here in Minnesota? Was there an employee that was directed by their supervisor to talk to the attorney for the purpose of exchanging that legal advice? Is it within the employee's sort of realm of responsibility that you would be talking to them, and has the communication been disseminated beyond those who are need to know? So it's a little bit of a slightly different, Minnesota's slightly different from almost all the other states in that regard. And then as far as foreign laws go, many of you probably understand there's a really high level basic distinction between common laws countries. Our law, we get our law basically from England, which is a common law country, and then there are civil law countries like the EU that are mostly based on statutes, where our laws are often based on court-developed doctrines. So in common law countries, they do often recognize a privilege. They may not recognize it to the extent that we do. Some of those countries don't apply it to in-house counsel as much, unless the in-house counsel it's kind of funny, is actually a member of the local bar association. They take that into consideration in some countries. But, in civil law countries, there really may not be this concept of privilege like we have, and it may not apply at all. And you're really relying on sort of rules that govern confidentiality among attorneys in those countries. And the protections are very different. So it's really important, if you do investigations in companies that do business internationally, to recognize that what you're writing in your work product and your communications may not be protected. They may be protected in the United States, but they may not be protected abroad.
It's also important to consider whose communications with counsel or with the investigation team may be protected. As Lucine just discussed, in some jurisdictions, employees outside the control group those interviews, those communications may not be protected. It's also unlikely that your interview with an employee is going to be protected if that employee is in an adverse position with the company or has an attorney who's sitting at the table with them. So be aware of that. Former employees, communications with former employees may be protected as privileged if the communication, if the interview involves something within the scope of that employee's former employment with the company, if they are really speaking to you as a representative of the company in the past. However, it really depends on state law. So there's a case in Colorado where it's fairly clear that privilege does apply if the interview is within the scope of employment. There's a similar case, a 2017 case that came out in the state of Washington that very clearly said communications with former employees, interviews with former employees are not protected by attorney-client privilege. So it's important to consider state law when you make decisions about who to interview and to know what the rules of the road are. There are other types of communications that may or may not be protected as well. So consultants and advisors. If you hire a forensic accountant, if you have a translator who's present during the interview, if you have a private investigator or a PR consultant, those communications may be privileged depending on the court and sometimes even depending on the individual judge who happens to be deciding the case, as long as the information that those consultants, those financial advisors, those translators, as long as what they're doing is necessary or essential to the giving of legal advice by the attorney to the company. Auditors, outside financial auditors, no. If you are communicating the results of an investigation to an outside financial auditor, you should understand that you've waived the privilege with regard to whatever you've communicated, because financial auditors have an obligation to disclose to the shareholders and to the public the results of their financial audit. So be aware that those aren't going to be privileged communications. Sometimes there's a rule called the common interest doctrine. And so if the investigation involves a matter where the company and maybe several employees of the company or maybe some vendors to the company are all potential defendants in a lawsuit or a criminal investigation, something called the common interest doctrine can apply. And that's when all the parties are really on the same side of the case and they want to be able to share information with each other. The common interest doctrine may allow the attorneys for all of these different defendants to share information with each other as part of a common interest. So sometimes co-defendants, sometimes when the employee and the company are on the same side of a case, their communications with each other can be protected as privileged. What about government agents? The answer to that is typically no. So even you might think that you have a common interest with the government, and I've had plenty of clients who think that when they, for example, discover an embezzlement. You've discovered that an employee was embezzling a bunch of information or a bunch of money from the company, and so you call the police and the police get involved and you tell them about everything that happened in the investigation. This actually happened with a client of mine, where they and before we got involved in the case, had called in the police and said, look, we've got this major vice president of the company who committed an embezzlement, and we've conducted our own investigation, and in our investigation, we talked to these witnesses, and Johnny Jones said X, Y, and Z. And those statements to the police, now in my experience, federal investigators know not to do this, but this was a report to state police, and they actually ended up putting those statements in their complaint without having gone out and independently talked to the people. So they were relying on the internal investigation to form their criminal complaint, and that got public. And then the company later on wanted to protect the investigation because there was some sensitive trade secrets information that got disclosed and also some sensitive personal issues that had nothing to do with the case. We were retained to fight that fight, and it was an uphill battle because they had already communicated all this information to the police. Well, we thought we had a common interest, and the reality is no, the government is not going to share a common interest with you about anything, so just be aware of that, even when you're on the same side.
All right, so that was a long step one, but those are some key things to think about. It's important to train and have your employees and anybody who's involved in investigating or could get involved in investigating to understand the basics of those privilege issues. So number two, put a lawyer in the lead. We're calling this one, and I know we talked about a little bit about that with Karen and Ruben and how you choose who's leading the investigation. Sounds like Medtronic has the luxury of being able to have an attorney, in-house counsel who's quote leading every investigation, and I think that's fantastic. I know that a lot of our clients couldn't possibly do that. They don't have in-house counsel themselves, or they can't afford that kind of a situation. So what we're asking, and what we're asking you to think about on step two is, when in the process of doing an investigation do you start thinking, oh boy, we need privilege, this might need to be privileged. There are serious issues here. We've got to get in-house or outside counsel involved. And so really, we like people to think of it in sort of steps. So there's sort of a preliminary inquiry, and this may be at the, HR, management, compliance level, where you hear of a complaint and you get some basic information. You maybe talk to one or two people and you have some, get some basic documents, and you start to get an understanding of what, this is about, and, what kind of legs it might have, and what could be the risk of this to the company, and what's involved. And at that point, if an attorney is not involved in overseeing that, at that point, nothing you're talking about, nothing you're gathering, no conversations you're having are privileged at that point. So the key is be thinking, when do I need to get counsel involved? What are the risks to the company that are coming up through what I'm learning here on that? I think that you want to then be thinking about starting a formal investigation if there's enough legs to this. Like Dulcie said, if it's just somebody constantly stealing lunches in the, workplace cafeteria, that's something that, you probably never have to worry about privilege with, and it's probably something you don't need to get a counsel involved in. But, my other example, which is more extreme, if there's kickbacks and there's huge potential for a government investigation, and somebody's bringing up a bunch of different allegations that could be really embarrassing to the company and has reputational risk involved. You want to be really starting to think about that, because, and that can be led by either in-house or outside counsel to get privilege. Dulcie and I, and we're not telling you this self-servingly. This is actually true. Courts really do actually view outside counsel versus inside counsel in a more independent light, and the privilege, decisions that courts make often favor privilege if there's outside counsel involved. I don't know that that's fair or that it should be that way, but that's how the case law tends to go on this. Courts view outside counsel as someone who's not likely to be biased or to be mixing legal advice with business advice, and also using outside counsel is obviously, as I mentioned before, recognized under other foreign laws. So those are some of the considerations you should be just thinking about when you're getting into the investigation and making sure that privilege is going to apply if need be.
So step 3, make a communications plan and stick to it. Well, what do I mean by that? I think it's important to, at the outset of an investigation, be really clear about who you're reporting to, and actually put that in writing. So when you make decisions about what to investigate, Ruben talked about scope creep. When you go back to somebody and said, okay, we learned about this, we're investigating this, but we learned about X, Y, and Z in the process of this. Should we go off and do that? Who are you asking those questions to? Who are you reporting the results of your investigation to? You need to have an understanding of that from the beginning. And sometimes that can be a complicated question, maybe more so than it seems at first blush, particularly if, let's say, the CEO of the company is under investigation. Who are you reporting to? Are you reporting to the CEO? I don't think so. That's not going to fly. If you have an investigation that involves high-level officials in the company, you probably shouldn't be reporting to the C-suite at all. You should be reporting to the board of directors or a special committee of the board of directors of the company. So that's a decision that needs to be made up front. And then any discussion with employees of the company about the investigation, and these employees may be witnesses, they may be document custodians. It's okay to talk to them when you need to, but only do that on a need-to-know basis. So make sure that you are controlling the information and only talking with employees who are outside of the reporting chain and the investigation team when absolutely necessary to obtain information. And don't disclose investigation steps at all to anybody who is outside the company or who is an adversary. So those are key things to keep in mind. It's also important to limit the size of the investigation team. Usually, the investigation team will include, and if it's a privileged investigation, it always has to include a lawyer at the lead. And you can also have paralegals, their assistants. Sometimes it's important to have IT personnel involved in the investigation because they're the people who are going to be out there actually collecting those electronic documents and helping you get access to text messages and phones and things like that. You may need to have an accountant. HR folks often need to participate in investigations because of their role within the company and be a part of that team that's led by the attorney. And you may need to have other experts who have particular expertise, and say you're investigating an OSHA violation and you need to know more about the industrial process that's being used in the company. Maybe you need to have an engineer who's on your team. It varies from case to case, but make sure that you have the right team put together from the beginning to the extent that you can. And I think Ruben or Karen mentioned this, it's incredibly important that whoever you put on the team is not somebody who's going to have a conflict of interest. And by conflict of interest, I don't just mean avoid putting the target of the investigation on your team or the subject of the investigation. You also want to avoid putting anybody on the team who needs to report to that person. So you don't want to have your vice president of the company on the team to investigate the CEO because he's reporting to the CEO. He's going to have a conflict of interest if he's going to have to come up with some bad findings that may affect his job. You don't want to have anybody on the team who's a key witness to what happened either. So be careful when you're putting your team together to make sure that it doesn't include folks with particular interests in the case. And you need to take care when any non-lawyers are on the team to make sure that they understand the rules that we're describing to you today so that they understand how important privilege is, that they should only report and take direction through the lead attorney, because if they're reporting to other people, then that could result in a privilege waiver. Attorneys should always be involved in retaining any outside experts that you may need to involve. And the contract with that outside expert should clearly explain that the attorney is directing it, because that will help down the road if you need to argue that the outside expert's contributions to the investigation are protected as attorney-client privilege or work product materials. Team members who are part of the company, who are employees, need to segregate their investigation materials from their other work. Otherwise, it's going to be difficult later on if there's a discovery request. You don't want to have to produce that other work in connection with the investigation materials and vice versa. So be sure that those materials are segregated. And then I also think it's pretty important to have attorneys actually lead the interviews whenever possible. Why do I say that? Well, because if the interviewee is not an employee or is somebody outside the control group, then there's not going to be any privilege, but you may be able to argue that the attorney's notes are protected under the work product doctrine. So that's important. Notes of folks who are not lawyers that do not contain legal work product and opinion are not going to be protected, and it's really hard to argue that if you've got a non-lawyer who's conducting the interview.
So step 4 arises right out of that discussion. So you've decided on your, small communications group, and you did a really good job of eliminating that initial group to the people that matter the most. But in the course of the investigation, it expands a little. There's the scope creep that might happen. And all of a sudden, the director of this division and this member of the C-suite and whatever wants to know what's going on and wants to hear regular reports on the investigation. Well, this section is just to remind you that, especially states where in control group states where there's a really restricted view of what internal employees can be spoken about, talked to, included on communications to have the privilege apply. You should just be aware of that you really do need to think about limiting, corporate communications internally and reporting throughout an investigation process to a small group of people who really need to know and who are really, not conflicted and able to control the investigation. And just, there's the handful of states, I think it's Alaska, Hawaii, Illinois, Maine, New Hampshire, Oklahoma, South Dakota, and Rhode Island. Those are the ones that have stuck out to this control group test, where other people have started to move to more looking at, other courts have started to look at more subject matter. And, whenever you're going outside the core communications group, because you have to consult with somebody, you need to be always thinking, remind them, this is confidential. Don't be repeating this. Don't be going to, such and such person that is on the internal communications team and poking them for information on the side, and just reminding people of that. I had an investigation once where we were investigating possible bribery of a public official, and I was dealing with the CFO on this investigation because the CEO might have been implicated and they didn't report to each other directly. So I was dealing mostly with the CFO, and I sent him a communication about what we were going to interview the main accusee of this bribery scheme, and he started forwarding this email to other people. I didn't know this internally, and then when I sat down with this person, I said, "I have a list of questions for you," and he's like, "This list? Are these the questions?" And he had the email that, and I had sent. And I was like, wow, maybe I didn't do the best job of making sure the CFO really understood how important confidentiality was. So, but it's a learning process, and you have to remember that everybody needs to be informed of that and keep that in mind. This thing doesn't always
Next step,
click.
cut off the grapevine. Everybody knows this. This is the bane of every investigator, the water cooler. People talking, it's really hard to keep a lid on things when something goes on, and especially when it involves a high-level person, but even when it doesn't. And sometimes maybe the employment group has to say, you know what, while we're investigating, we're going to put John Smith on, paid administrative leave. Well, everybody wants to know why John Smith is on leave, and there's lots of people talking about it. This is dangerous because it could subject the company to defamation lawsuits, depending on what gets said. If it gets out put in the public, it puts privilege at risk. You can't always prevent this from happening, but you have to try. So I'll just put it that way. One thing that you can do is to warn your control, when I say your control group employees, the people that you're reporting to about the investigation, against discussing it without counsel present. If they're doing crosstalk with each other about the investigation, that could waive privilege on it. So one way to contain that is to warn them that they really need to limit their communications with each other, particularly their written communications with each other about the investigation, unless counsel is present. You need to instruct witnesses and document custodians from whom you're collecting information about the need for confidentiality. It's a really, really important thing to remember to do. And then gossip is going to become rampant anyway sometimes. And when that happens, it may be important to send a note out to all the employees and say, look, we all know that this is going on, and this is a case-by-case thing. I'm not saying you should do this in every case, but sometimes it's necessary. Send a notice out to folks. We know that everybody knows this investigation is going on. Don't talk about it with each other. If you have any inquiries about what's going on, please direct it to the lead investigator, and do all of this knowing that some people are going to ignore your instructions and do it anyway. It's the best you can do.
So step number 6 in protecting privilege in internal investigations: separate legal and business advice. This is actually really important, more important than I think people really generally realize. There's a big case in 2012 involving a local retailer to Minneapolis, large retailer who was they were sort of automatically substituting for customers their store card for a brand new Visa card. And there was a class action against them. And in the course of that litigation, there was an issue involving, I think it was like 400 documents that company had tried to claim privilege on. And there was some fighting back and forth, and finally the court reviewed all of these documents in camera itself. The court looked at these documents and made its own determination. And, basically most of them weren't protected. One of the big things the court said, it looks like you're just blending business and legal advice back and forth throughout these emails. They're all mixed up. They're all to different people, some, business heads of business divisions, others attorneys. And the court basically said, I don't think almost any of these are privileged. So, this does make a difference in, to courts, and they look for this. So, how do you do this? How do you separate this? Think before you email. And that doesn't just apply to, I have on the slide, in-house attorneys should send separate emails for business and legal advice. But it's good if you all who are emailing your in-house counsel or your outside counsel or whoever, that you say, you're thinking this is really, a legal question, and then you're separating your question to them for business too. It would be really helpful for them to be reminded of that. But if you're getting 2 separate emails, or the in-house counsel, don't get irritated at them. They're doing it, on purpose to sort of protect the privilege. And then board minutes, they should note when the discussions about, an ongoing investigation, for instance, are held with company counsel under privilege. The minutes should be very clear about that. Ideally, the minutes don't even reflect really much of the content of that conversation, if any at all, but that should be clearly marked. And then, of course, investigation team members should always be marking. We'll talk a little bit more about labeling things, but they should always be trying to mark things that are intended to be privileged with some kind of a label of privileged or work product as they apply. Oh yeah, I'm on this one too. So here we are, label documents accurately. This is what I was just referring to. So I think there's a misconception out there, even among attorneys, and Dulcie referred to this, that if you just say on the top of any email or memo or communication, if you say privileged and confidential, attorney work product, protected, or whatever, that you put some words on there in bold, that, everything's fine and everything's privileged. Well, not true. We've already talked about some of the myths related to that because there are more aspects to privilege and what's protected than just putting a label on it saying this is a privileged communication. So I think there's both an under-reliance and an over-reliance problem with document labeling. And so my under-reliance problem is, it's really easy to do this, and people often don't do it. It's really easy for me as general counsel of Fredrikson Byron. If somebody's emailing me about a legal issue and they're seeking my legal advice for the firm, I do my best to say privileged in the subject line or in the email, somewhere. That's it's easy to do. There's no reason not to do it. If you're emailing your in-house counsel seeking legal advice, it's easy for you to just put privileged at the top in bold letters or something as well. So, but then there's also the over-reliance issue. So, there's no guarantee in and of itself from that label. I think, people over-rely on that, especially in terms of work product. As I have said before, work product designations, those are really for situations where you're anticipating litigation. The problem with putting work product on everything you're doing, even if you don't anticipate litigation, is that you're inadvertently going to trigger this other requirement that if litigation is anticipated, you've got to preserve documents. You're under it is your obligation to preserve related information, and that you could be accused later of spoliating information. So you've got to be aware of that too, that you can overlabel. And if you just label everything, courts are going to look at that, and they have. There are court cases where they've just said, they've just labeled every single thing they produced in discovery as privileged and confidential, and the courts aren't gonna. They're gonna say, forget it. You haven't done this properly, and there's no way I'm sorting through these 10,000 documents to figure out which ones actually are. So, something to be aware of.
All right, step 8, don't record interviews. I think Karen alluded to this when she said don't make your interview notes look like transcripts. An even worse thing to do would be to put on a tape recorder and try to record that interview, because in the state of Minnesota, interviews that are recorded have to be turned over. And that's true of a lot of other jurisdictions as well. So don't turn on that tape recorder, don't record the interview, don't make your notes like a transcript. You are increasing monumentally the likelihood that that's going to have to get disclosed in litigation. A best practice is to bring a note taker, as Karen was suggesting before. And then, I've already talked about this one, handle interviews with care. So another bad thing to do is if you've got something that a witness says during an interview, to write a statement down and have them sign it. If you want to do that, understand that that statement is going to be disclosable under court rules. Federal court rules require that signed and adopted interview statements get recorded or get turned over. Same thing with the state of Minnesota. So it may be necessary. There may be times when you want a signed statement, but just understand that that is likely to get disclosed. And don't use privileged documents during interviews to refresh a witness's recollection. And the reason I say, and if you can avoid it, and the reason I say that is because interview notes and reports we despite everything we do to try to protect them, you could be in a situation later on where those are going to have to be disclosed. If you're showing the interviewee otherwise privileged materials in the course of that interview, then that's going to go into the notes. That could end up jeopardizing the privilege over the materials that you're showing them. Then Reuben talked about the upjohn warning. This is an absolute requirement for in-house counsel. Lawyers who do investigations talk about this all the time. It should apply not to everybody that you might interview, but it should apply to anyone for whom a company privilege might apply. So current employees, former employees, if those former employee interviews might be protected, company representatives, give them an Upjohn warning. Lawyers have to do this. It's based on a case called Upjohn, by the way, so that's where it comes from. It's mandatory for lawyers, and it could actually be an ethics violation for lawyers not to give an Upjohn warning because it prevents interviewees, giving them that warning, from mistaking the lawyer for their lawyer. So you got an employee, you're talking to them about the case, and the employee says later on, oh, I thought this lawyer for the company was representing me too. So lawyers have to do this. But it's also a good practice if you're not a lawyer to do this because it helps preserve the privilege. I've got a slide here that talks about the steps of the Upjohn warning. I think Ruben went through these before, so I'm not going to go through them. You've got them in your materials, but these are the things that go into an Upjohn warning. Just be mindful of the need to do that.
And finally, okay, so you've done everything right so far. You've, labeled your stuff appropriately. You've limited your team. You've been very careful to let an attorney lead, and you think you're great. Well, what goes wrong in the very end? Well, you disclose something to a third party that was privileged, and you've waived the privilege over some or all of the investigation. So that's our last step, is just to be aware of this, this problem. And Dulcie's already alluded to government agencies. So oftentimes government agencies who are doing an investigation may be based on a whistleblower, False Claims Act case. They're going to want, they may ask you for things. They're going to want information from your internal investigation. And there are complicated rules with the government about when they can, what they can ask for and when they can. But, the state level investigators aren't always as savvy about this, as Dulcie said, as the federal government is. So they could, they could ask you for things, and you trying to, in a spirit of cooperation, either to, get the company out of trouble or because the company's really not the focus, you may, give this, and then you've waived privilege as to all of those materials. Now, disclosing underlying facts do not waive privilege, and that's probably part of the reason Karen separates out her factual memos from her legal opinion. But, you can disclose underlying facts to government investigators, and you should be very wary that when you're writing things and you're preparing things, that you want to be able to do that. And so to the extent that you can be aware of that when you're writing up your reports, and either those are going to be entirely privileged or you're going to, have an ability to separate out a factual inquiry.
I'd like to just make a quick comment about that. I mean, I think companies end up wrestling with this when there's a criminal issue and the government says, I want you to cooperate with me. I want you to give me your information, but you may not want to disclose the whole investigation to the government agent who's involved. There are ways to do that, and one way to do it is something that we call an attorney proffer, where the attorney just goes in and talks to the investigator and doesn't say, I did an investigation and this is what the witnesses said. That's a thing not to do, but goes in and says, so our understanding of the facts is this. Our understanding is that John Smith harassed Mary Jones on May 5th, and this is what happened. So you're disclosing the facts. You're cooperating with the government, but you're not disclosing, this is what a witness said to me in the investigation. You may be saying to them, you may want to talk to these 5 individuals within the company about this. So you're giving them a list of people that they can talk to, but you're not saying, I talked to those 5 people, and here's what they told me. So there are ways around this issue whenever the government's involved.
And we also alluded earlier to the fact that disclosures to company auditors probably waive the privilege. So, to the extent you can avoid disclosing an investigation report to your auditors. And then outside insurance companies, maybe. That may be protected under a common interest.
And that's it. Now Pam wants to.
All right.
Going to invite Karen and Ruben back up to the stage for our question and answer period. There are a ton of questions, and they're all really good. So I had a really hard time pulling out which ones going to have them answer, but everybody had really great questions. And while everyone's getting situated, I'll just tell you very quickly a little success story on behalf of one of our clients. We have a lawsuit right now in federal court. It's a sexual harassment lawsuit. And last week, the federal judge on the case commended reprimanded our client 3 times from the bench on how they handled a sexual harassment allegation. And the story went like this. The employee resigned and in her resignation letter disclosed that she had been, or that she perceived she had been sexually harassed and that she hadn't disclosed it previously and that was why she was resigning. The resignation letter came in on a Sunday night. On Monday morning, the HR person had already started an investigation. The HR is located out of state. This happened in Minnesota. The HR person already had determined who's going to do the investigation by Monday morning. That person was traveling and in Minnesota by Monday. And by Wednesday, 2 people were fired. And the employee had been interviewed, even though she was resigned. The former employee had been interviewed. They had asked her to come back, and they had verbally counseled a 3rd person who didn't get fired, and then scheduled a training for everybody at this particular plant in Minnesota to come back, for someone from HR to go there and retrain them on the sexual harassment EEO policies. They had a really good sexual harassment policy that the plaintiff failed to take advantage of. And so 3 times the federal judge said from the bench, I don't think I've ever seen anything like this. That is an incredibly fast and thorough response, and that will obviously serve you well. And the plaintiff still sued, so lesson is that it won't, even if you do everything right and have a federal judge say, wow, that's impressive, you still might get sued. But it certainly bodes well for them in the lawsuit, which we've now settled. All right, so everyone's long been settled now while I told that story. First question is, and I'm going to ask it to Karen, and anyone can jump in. The question is, what do you say if the subject of the investigation says he or she feels the investigation or the allegations have hurt his or her reputation? I've had situations where the person being investigated has asked the company to make a statement basically clearing their name once an investigation concluded they have not engaged in sexual harassment. So Karen, what do you do when someone raises the concern that their reputation has been hurt and that they want their name cleared?
So I actually think that's a pretty common thing right now. And as an employer, you have to be concerned about a claim like Pam was just talking about from the person who's bringing the complaint. But more and more, I think you also have to be concerned about a claim from the person who's accused. If the person says, I want you to clear my reputation, that's a difficult ask. That's a hard thing for you to do without breaching the privilege and without violating the privacy of the other individuals who are involved in the investigation. So I would try to find some sort of creative approach to dealing with that issue. So for example, let's say that it resulted in a finding of the person didn't engage in whatever the allegation was. There might be a way that you could work with that individual and make some kind of joint communication to a limited group of people about the outcome of the investigation, not substantiating the allegations. But even that, I think, is pretty risky, and it would be pretty limited circumstances in which I would agree to do something like that or suggest doing something like that. But I always say never, and look at whether or not there might be an option to do something to help that person, because otherwise, as the company, what you're facing is a claim. That person's just saying to you, I've got a defamation claim against you. And it might be a valid claim, it might not be a valid claim, who knows, but you just as soon, particularly if you've gone to great lengths to keep all of this confidential, you just as soon not have that allegation out in the public eye. So I would try and find some sort of middle ground with that person if I could. Again, protecting the privacy of the other people who are involved.
Anyone else want to jump in? Move to the next. Okay, Ruben, this is for you. We have 2 questions about the same topic, so I think we need to address this one. The question is, not the accuser or the accused, but the witnesses. What do you tell them in the investigation about the investigation? How do you set up the interview with them? So this is either beforehand or during the interview, and describe for them what it is you're there to talk to them about.
Yeah, so that's a great question. So a lot of times, again, we try to have very consistent language that we've used. And so we actually have an email or some template language that would be used to go out to witnesses. And typically what we would say is that, some concerns have been raised or some issues have been raised without really getting into a lot of detail, and you've been identified as someone who may have some information about those issues. And we want to talk to you about that. Because again, a lot of times what we'll do, Karen mentioned, you start with some general questions. We don't want to lead witnesses on, so we don't want to give them a lot of information on the front end. We want to see what they know or what they'll maybe provide to us. So that's why we'll try to say, I told you we use the voice your concern line. So, if a complaint or an issue has been raised to the voice your concern line, because people know what that is, you've been identified as someone who may have some information, we'd like to talk to you about that. So that's typically how we would approach it and what we would use.
I'll just
Yeah, go
jump
ahead.
in there and say one other thing. So I've sometimes seen employers back away from using the word investigation because that sounds troublesome to people and it sounds scary and they might not want to be quite as forthcoming. And so sometimes, and I don't think there's one right or wrong way, but sometimes I see people calling these audits even lately or fact findings. I think fact finding is a pretty safe word to use. So again, as you're setting it up, if you're explaining what you're doing, we're conducting a fact finding, I think is a fair way to describe it.
And Karen and Ruben, from an employment law perspective, from the EEOC's perspective as well, can you tell witnesses that they have to keep it confidential? Or can you tell anyone in the investigation that they have to keep it confidential?
Well, you're probably going to get a lawyer response and an in-house lawyer response. Because you want to start with what you would say?
Go ahead.
Well, I think that question comes about because there has been some NLRB rulings, National Labor Relations Board rulings about that you can't tell employees that they have to keep investigation material or the process of the investigation, the questions confidential. Now that is a little bit up in the air. I think probably right now at this point, given changes in administration, our approach to Medtronic is that we still have, in general, said you need to be mindful, you need to keep this confidential. We don't want you to discuss it. And our position on that is that it would impact the quality of the investigation if they went and talked to people about the investigation or did their own investigation or asked a lot of questions. We want to be able to ask people those questions. So, I don't know what Karen.
No, it's very similar,
Yeah,
actually.
it's okay. So, sometimes we've had some outside attorneys say you absolutely can't do it, but I think we try to be a little more flexible given that.
Yeah, and I think I do too. We didn't obviously compare notes in advance, but my approach is pretty similar to that. First of all, the NLRB rules about keeping information confidential they apply whether you've got unions or not, right? But they only apply to people who are not supervisors or managers. So we're not worried about telling them to keep things confidential. We're just talking about folks who could be in a union, so they're not supervisors or managers. And I agree with Ruben that there have been, so the National Labor Relations Board is a very political entity, and it swings, it's 5 people, and it swings based on whoever the president is. Under the Obama administration, the NLRB was very aggressive about saying you cannot tell employees they can't talk to each other about anything. They invalidated even respectful workplace rules. That, as Ruben just alluded to, that has begun to change under the current administration. In fact, there was a case that came down in December. That's really begun to change, and I think that is going to have a very short lifetime now. So I would not be overly concerned about telling employees they need to keep the information confidential. I think where the rubber might meet the road is if you find out someone didn't, are you going to discipline them or not? And that's where you're going to be a little more flexible, I would guess. But I also think saying that this is for preserving the integrity of the investigation is a good thing to do. That way, even if those rules haven't quite changed yet, you might have an opportunity to explain the rationale, and having a legitimate reason for why you're telling people to keep it confidential will help tremendously. So I would be with you on that, and I would definitely say it's for the integrity of the investigation.
I would also argue, given the perspective that we come from, we pretty much always ask, we at least make the request that the employee keeps it confidential, and we're not in a position to discipline someone, and I think that's, as Karen just said, a completely different issue. But if you have a serious criminal issue that's at play and could be exposing the company to criminal liability by not keeping it confidential, you have to, there's a balance that has to be put into play at that point. And if the balance is, well, am I going to get in trouble with the NLRB, or am I going to get the company indicted for a crime? then confidentiality, the need for that is increased in those types of very serious situations. So.
And I appeal to people on reputational risk. I say, this is the company you work for. This is these people's, lives and reputations. Like I said, especially in what Dulcie and I do, these are sometimes, sort of almost bet the company cases, or people could go to jail. And so I will sometimes lay that out on the table for people and say, this is why it's really important, and hopefully that helps.
Right.
Next question is for Dulcie. Dulcie, are there any reasons other than time and cost that you wouldn't prepare a final report at the end of the investigation? When I say you, I mean, anybody in this room too who might be doing an investigation.
Yeah, so we talked a little bit about doing investigation reports and the need to document things. I think if you are anticipating that there is going to be an inquiry where you're going to need to prove that you did a comprehensive investigation down the line, it may be necessary for you to document in that case. If you have a client that is reporting, this is an investigation where you're reporting to the CEO, and the CEO needs to then report to the board of directors about what your findings are, it may be useful, it may be a good tool for them to have a report to document that the investigation was done. But if you are investigating something that's purely internal, that you want to keep the fact that the investigation was done internal, it's a very sensitive issue for the company, and you're not anticipating a situation where you're going to need to disclose that you had an investigation and here were the results down the line, you may want to think seriously about not doing a report, because by creating a report, you are simply creating evidence that could, despite all your efforts to keep it privileged, ultimately get disclosed and expose the company to either civil or criminal risk. So when I started an investigation and developed that communications plan that I talked about, one of the things that I always put on the table for the discussion is a discussion with the client about whether they want a written report or not. Some situations, I think you really don't want to have one. It actually exposes the company to more risk.
This is a question that gets asked at almost every seminar, and it continues to be a problem for people. So I'm going to ask it to everybody on the panel. Lucine, maybe you want to start. Anyone else wants to jump in. The question is this: do you have any advice on how to handle an investigation when there are no witnesses and the situation is he said, she said? And I'll just add to that by saying, do you have to then make a credibility determination between those two people, or is it ever appropriate to say it's inconclusive?
Well, most of the investigations I deal with aren't sort of the he said, she said situation often. I mean, there may be elements of that when you're dealing with embezzlement or something like that. Most of the time, I deal with situations where the government's investigating. But you do have to, in those investigations, we do have to make credibility determinations and make decisions about whether we have to report to the government certain behavior. And so, yes, even in a he said, she said situation, we're going to be presented with advising the company on what to do with respect to reporting misconduct, to a government agency. And I would have to make that decision in that situation. So but that's from our perspective. It sounds like that's maybe more of an employment law sort of.
Well, I have done a sexual assault allegation investigations, and in those situations, yes, absolutely. I think you are listening for cues. Is the witness somebody who is going to answer your questions, or are they somebody who's really going way out of the way to avoid your questions? Is the witness somebody who's been interviewed more than once and says something different every time they're talked to? These are all things that we take into consideration. Is the claim that they're making something that's really outrageous or that isn't consistent with the facts? So she might say, this happened in this building and in this particular room, and it turns out that that's a locked room that nobody can get into. You have to make credibility assessments based on the facts, based on the tone of voice. Some witnesses may be incredibly sincere. They may believe their allegation, but they may be deluded. You may have a situation where you have a witness who is actually very credible and sincere in their presentation, but whose claims really are not something that can be substantiated in a way, they don't make sense based on all the other facts that you know. And you may come to the conclusion that they believe that it happened when it didn't. So those are assessments that we always, I think, have to make no matter what type of investigation we're doing.
Yeah, I would say in the employment law context, we try really hard to come to a conclusion, and it's a little bit unsatisfying to say we can't reach a conclusion one way or the other, but if that is the truth, because you just can't, then that's the truth, and that's where we land. But generally, we look at whether or not what we're being told is plausible. Is the denial plausible? Sometimes when you have he said, she said, you will have very specific, detailed allegations on the one hand and very generalized denials on the other. I tend to credit things that are specific and detailed. And so I think that is something I would point out if I were making a credibility assessment, that these things were particularly detailed and specific, and it would be hard to make up all of those details. And yet we had a generalized denial, or I don't recall, I can't remember that particular episode. So I think those things weigh in as well. And to know that it's never crystal clear. I mean, some things are clearer than others, but a lot of times you do need to use your best judgment about what makes sense. Is this a again, plausible story? And to that end, I think it's also really important for the investigator to be clear about the burden of proof. So, and what level of proof they're using. You're not really bound by court decisions or legal standards, but, do I look at this and say I think it's more likely than not that this happened the way this person has alleged it, or do I think it's more likely than not that it didn't happen that way? And at least explain that standard that you're using.
Yeah, I mean, from our perspective, we would say that you should find a conclusion every time you do an investigation. You have your weight, you're balancing, a feather. A feather can make a difference and push it. Okay, so even if it's a teeny little bit, that could push it. I mean, that's what we're talking about with the investigation, that we want to have a finding. And it kind of goes back to what I talked about. That's why when you do those investigations, you want to make sure that you've done a thorough job gathering all the information, all the facts, so that you can weigh it. At the end of the day, you're making a decision about, okay, here's the facts. There's facts on this side, there's facts on this side. There's credibility determinations. All that can play in, so at the end of the day, you make a conclusion based upon this. This is my conclusion. So again, it's a little bit different, I mean, maybe, but that's what we try to push towards that. So we're not saying, I don't know, could have happened, might not have happened. We're going to say, there's not enough evidence to support that it happened. It's not corroborated. And then if additional information comes, you can reevaluate. But that's probably how we would look at it.
Yeah.
We got the 1-minute warning, so I'm just going to do one last question, which I think has possibly a quick answer. And we had 2 people ask whether you should let someone being interviewed, in particularly the accuser, the person who's claiming to be a victim, bring a family member. So I know we talked about counsel earlier, but should you let them bring a family member for support, emotional support?
No.
No, I would let him bring a lawyer, but not a family member.
Ditto. Maybe.
I would say no. I mean, has it ever happened? We've had some situations, given emotional stability and whatever else, where to get it done, we have. But I mean, I would agree in general, no.
You just waived privilege, though.
Yeah.
No, I
Right, so,
understood.
I mean, just understand
Understood,
that.
yep.
Yeah,
Yep.
but it's okay if you intentionally waive it,
Right,
right? Thoughtful waiver.
I suppose, what if you had an employee who was 17 years old?
Then you.
No.
have
See,
to let 'em.
lawyers can turn anything into it.
This was supposed to be yes or no question. Okay, that's it. We've got a reception out in the hallway, and thank you all for your time.